This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
All right. So now I have the distinct pleasure of introducing the speakers of our morning ethics program. You Said What? Hot Topics in Legal Ethics, presented by the Honorable Suzanne Bruguera, David Fink, and the Honorable Mary Fingal Schulte. So first, as one of the youngest judges appointed in California, Judge Suzanne Bruguera was 33 when the governor appointed her to the bench in Los Angeles. She joined ADR services after 27 years as a judge of the Los Angeles Superior Court and former municipal courts, with the entirety of her time on the bench spent in civil assignments. Responsible for handling hundreds of cases with unlimited jurisdiction as an independent calendar judge, Judge Bruguera was known for negotiating difficult settlements and for conducting controversial high publicity jury trials. She is well-respected jurist known for being firm, fair, and able to settle cases which other settlement officers could not. Judge Bruguera's judicial career was preceded by experience as a Deputy Attorney General for the California State Department of Justice, where she handled complex business and tax matters and Medi-Cal fraud for nearly 5 years. Prior to that, she was a Deputy District Attorney for the County of Los Angeles, prosecuting child molestation matters. Next, David Fink has over 35 years of experience in the field of family law, including 20 years as a litigator and 30 years as a mediator. Since 2008, David's practice has been limited to a neutral work as a mediator, private judge, and referee in financial and parenting disputes, and serving as consulting attorney for individual clients engaged in consensual dispute resolution process without litigation. He is a certified fellow and past president of the Northern California chapter of the American Academy of Matrimonial Lawyers, and has been certified by the State Bar California Board of Legal Specialization in Family Law for 30 years. David is a past chair of the Family Law section of the California Bar Association and received the Family Law section's Distinguished Service Award in 2007. He has been selected as a Northern California super lawyer since its inception in 2004, and in 2006 was selected to the Super Lawyers Top 10. And lastly, Honorable Mary Fingal Schulte retired from the Orange County Superior Court in 2017 after 20 years on the bench. She enjoyed a distinguished judicial career as a respected trial judge, having herself been an experienced trial lawyer and civil litigator for nearly 20 years before her appointment to the bench. In 2016, Judge Schulte received the Trial Judge of the Year award from the Orange County chapter of the American Board of Trial Advocates. For the last 14 years of her judicial career, Judge Schulte held various civil assignments and has presided over general jurisdiction civil trials, probate and mental health hearings and trials, appellate panel hearings, and long-cause family law trials. She was supervising judge of the probate mental health panel from 2009 to 2014, and assistant presiding judge of the appellate panel from 2008 to 2009. In addition, she was actively involved in several court committees, including the Executive Committee, the Temporary Judge Committee, where she developed and supervised the first court-wide training program for the court's temporary judges and a settlement training program for the probate panel's temporary judges and the Arbitration and Mediation Committee. So without further ado, passing it to you, speakers. Please turn on your videos.
Hayward, if I could prompt you just for a moment to send out the poll. We wanted to get a sense of the audience about how many, what kind of practice people have that will help us tailor the program a little bit for different audience members. And while you're responding to the poll, we wanted to start with a quote from a case that we will be discussing in quite a bit of detail later in the program, but we thought this was a perfect statement to sort of start our program and tell you our theme. Attorney skill is a traditional touchstone for deciding whether to adjust a lodestar. Civility is an aspect of skill. Excellent lawyers deserve higher fees, and excellent lawyers are civil. Sound logic and bitter experience support these points. Civility is an ethical component of professionalism. Civility is desirable in litigation, not just for its own sake, but also because it's socially advantageous. It lowers the cost of dispute resolution. The American legal profession, here's a newsflash, the American legal profession exists to help people resolve disputes cheaply, swiftly, fairly, and justly. Incivility between counsel is sand in the gears. Incivility can rankle relations and thereby increase the friction, extent, and cost of litigation. Calling opposing counsel a liar, for instance, can invite destructive reciprocity and generate needless controversies. Seasoning a disagreement with avoidable irritants can turn a minor conflict into a costly and protracted war. All those human hours, which could have been put to socially productive uses, instead are devoted to the unnecessary war and are lost forever. All sides lose, as does the justice system, which must supervise the hostilities. By contrast, civility in litigation tends to be efficient by allowing disputants to focus on core disagreements and to minimize tangential distractions. It is a salutary incentive for counsel in fee-shifting cases to know their own low blows may return to hit them in the pocketbook. Mary, do you want to start talking about some of our recent decisions that have come down?
Okay, yeah, let's pull up slide 4. I think we skipped that slide. David was quoting from the Carton case, which we'll hear more about later. Well, good morning, everyone. Thank you for attending today. I feel like the first person in a buffet line. It's a little bit of, I don't know how many buffet lines we have anymore, but I've always been conscious of the fact that, don't take too much on your plate. You got to see who's coming up down the line. So as the first panelist speaker, and we're going to do some roundtabling too as well, I will probably be a little bit quicker because I really want to make sure we cover what we have, and it's a very ambitious agenda. So I wanted to kick off with appellate cases. Hayward, thank you for that nice introduction. I was hoping nobody was doing the math like, okay, she was a judge 20 years, a lawyer 20 years, retired 25 years ago. Yep, I got my ticket to practice December 1977, when the bar numbers were 76,000 or so. So now we're 300,000 or more. And I have noticed over the last 10 to 15 years, a real uptick in cases, published cases from our courts of appeal, and here in Orange County, especially, they're latching on to it on the matter of civility. I was never an appellate specialist. I did some appeals, but generally the standard for publishing a case is it's making new law. So the courts of appeal are publishing these cases on civility, which is the repeating standards that have been in effect for a long time. So the first one is a very recent one out of our district, Chappelle versus Chico's. And we all assume that the class can read, so I won't be reading from the PowerPoints. And that is one of the handouts. There's 2 handouts I wanted to mention that you'll have links to. One is the PowerPoint, and the other one is called Handout. And so we'll refer to that. So in the Chappelle case, that was a case where a default was taken when the attorney taking the default of the defendant knew there was opposing counsel. So the Court of Appeal said the attorney has both an ethical and statutory obligation to warn opposing counsel if opposing counsel's identity is known of the intent to seek a default. And they referred to the LaSalle case, which will be on a subsequent slide. The LaSalle court urged a return to professionalism in the hope that party attorneys seeking default would act with dignity, courtesy, and integrity. This is strong language. This case demonstrates the unfortunate reality that some members of the legal profession have not demonstrated the yearned for professionalism and the hopes expressed in LaSalle. And another thing, because a real bugaboo of mine is a trial judge and spending a lot of my time on the bench supervising other judges, ethics applies to judges too. So the Court of Appeal says this about the trial court who granted this default. The trial court inexplicably denied the motion to set aside the default, failed to address breach of ethical and statutory duties by Chappelle's counsel. So I don't think you want to be either the attorney or the judge on the receiving end of one of these opinions, because our courts of appeal have lack of civility on their radar, and they are reporting lawyers to the state bar. I mean, it's the 3 C's: civility, courtesy, and cooperation. These decisions all say they're not mutually exclusive. So I would encourage you to read this case. It's really a good case. And sometimes when we do these MCLE programs, I think probably preaching to the choir, because the people that should really know about this stuff tend not to sign up for things on ethics unless they have to. So next slide. I think we get to the LaSalle case. So LaSalle versus Vogel is also out of my appellate district. And the judges on our panel were all trial court judges, so they know what goes on in the trial court. And I knew as soon as I read the opening line of this opinion, the policy of the state is that parties shall cooperate, period, full stop. That's Bill Bedsworth, who I've known since we were baby DAs in the late 70s. And he is really committed to making sure civility happens. So they published this case after a little bit of a hiatus in published cases, because as attorneys, you all know, some are published, some aren't. So in that case, he wasn't particularly kind to the trial court either, which, they feel like the trial court's ignoring these ethical issues. So that's one really worth reading as well. And I'm assuming you can read, so I won't read it to you. I did want to read just one thing that wasn't up on a slide. Quiet speed and unreasonable deadlines do not qualify as cooperation. Attorneys who do not comply with that obligation are practicing in contravention of the policy of the state. And here's a strong word: menacing the future of the profession. So next slide. This is where are you? I don't have the slide clicker. Next one, Hayward, slide 7. Oh wait, sorry, go back. I'm getting over a flu bug too, so my brain's a little fuzzy. So I thought this was really a good quote that LaSalle ends with from Justice Berger in 1971. 71 sounds like it was just yesterday, but I'm thinking, man, that was like 52 years ago, 3 years before I started law school. And it's a good quote, and I won't read the whole thing, but he talks about knowing how to think is not the same thing as knowing how to behave. So thinking and behavior goes together, and again, uses strong language about a menace and liability to the administration of justice. So it's a good quote worth remembering. Now you can go to the next slide. Hayward, the Osborne case. So the Osborne case, that, unlike the other two, didn't have to do with taking a default against a client who defaulting counsel knew had counsel. This one deals with violation of motions in limine. And I'm not going to go into all the facts because you've got the site, you can read the case. But it's a reminder of the attorney's obligation as an officer of the court. In Osborne, the trial court did what trial courts really just love, getting all those motions in limine. So made a lot of orders on motions in limine. And from the get-go, opening statement, offending counsel started violating those motions in limine. And what I liked about this language is whether the court gets its order right or wrong, because, once in a while we don't get it right. Not that often, but usually the Court of Appeal will take care of that. But whether the court gets it right or wrong in the order, you need to follow the court orders. And it's probably not a good idea just to say, well, with all due respect, Your Honor, I disagree, whatever. So the Court of Appeal here says whether the trial court gets it wrong or not, that doesn't excuse you from bad conduct. And in this case, After numerous admonitions, the trial court granted terminating sanctions. And we all know from the discovery statutes that there's somewhat of a policy to escalate sanctions. But in this one, the Court of Appeals said repeated violations of court order, terminating sanctions are okay and appropriate and within the court's discretion. We love that word, discretion. And a takeaway, again, that I like to remind attorneys of, because a lot of attorneys aren't familiar with the code of the canon of ethics that judges have. So judges actually have an obligation to ensure that there is civility in the courtroom and that their orders are complied with. So next slide. Where are we? I think the next one takes us to David.
I think this is me. Yeah. Boy, if this is you at less than 100%, Mary, you must be fearsome at 100%.
2 cups of coffee.
Yeah, okay. So this is probably literally the most recent development. The Supreme Court approved these new rules in October of last year, and they are effective as of 18 days ago. And mostly what these do is these changes affect how you handle client trust accounts. And essentially what the Supreme Court granted the state bar was permission, actually it wasn't permission, granted them a mandate and actually told them what they needed to do was to create what they now call the Client Trust Account Protection Program, or CTAPP, as you'll see on the bar website. Now, basically what the mandate is from the Supreme Court is the state bar is required to require of practicing attorneys trust account certification and registration every year. And those of you who have renewed your bar membership already this year will have come across the questionnaire that we'll talk about in a minute. In addition to those 2 mandates, there were sort of 3 permissive things that the bar was entitled to add. And as a matter of fact, they actually answered all 3. Included all 3 in their program. So one of the changes here was that they, instead of describing attorneys or some other way to describe those of us subject to these rules, is they refer to all licensees responsible for trust funds. And again, the certification is basically you have to say, do I have a trust account and am I holding funds? And you also have to say, this is where my trust account is. It's at this bank with this routing number and this account number. So that is now all going to be part of the state bar rules. In addition, as again, one of the permissive things that the Supreme Court ordered is that you are now required to complete this self-assessment test on trust account duties, which basically requires you to, certify that you understand essentially all the aspects of what is now Rule 1.15, which is the California Rule of Professional Conduct that it has to do with trust accounts. And that includes all kinds of things, including maintaining that the accounts, your trust account is being maintained in a bank that's been approved by the state bar, that your account is labeled trust account, that you are maintaining for all clients a client ledger, an account journal, bank statements, and canceled checks, that you are reconciling those things every month, and that you do provide timely reports to clients or other persons who are either actual or potential owners of the funds in your trust account, giving them notice of when money is received and disbursed. Now, some of those, Rule 1.15, let's see, next slide, please, Hayward. So these are the changes to 1.15, which is the trust account one. So what are the rules they changed? Is the old rule used to be, if you received money, you were supposed to promptly give the client notice that you've received the funds, but promptly wasn't defined. In the new change in the rule, it is now you not only must notify them more or less promptly, but there's a 14-day limit. So within 14 days of receipt, you are required to give written notice either to a client who's paying a retainer, or if you've received settlement funds. Anytime you've taken money into your trust account, you need to give that notice. Another change here is under the old rule, if you had trust money, you were supposed to distribute the money upon request. That is now changed. Now you are required to promptly distribute any undisputed funds or property that the person is entitled to receive. And there's a limit to that, which is 45 days, unless there is a separate written agreement or a court order that holds that, that delays the distribution of the funds. And they have gone ahead and updated the definition of undisputed funds and property, which you can see here on the slide. But basically, it's where the lawyer or the law firm reasonably knows that there are no longer any disputes concerning who has the funds. And let's see, when we were practicing, I was, let's see if I can find this. So this does include things like, are you going to ask me the question, Suzanne?
Yes, David, I was going to ask you if that notice requirement also applied to those who may have a lien on the account, because it seems like this could be quite a duty, quite something that people really need to be careful about.
So funny you should ask that, Suzanne, because actually comment 7 to Rule 1.15 says that these disputes about who owns the funds can include but are not limited to disputes medical liens, statutory liens, prior attorney liens, costs or expenses, attorney's fees, a bank's policies and fees for clearing a check or draft, any applicable conditions on entitlements, such as a plaintiff's execution of a release and dismissal, or any legal proceeding, such as an interpleader action concerning the entitlement of any person to receive all or a portion of the funds. So other than adding a couple of reasonables in there, that part is not really a big change. But what is a big change is it's not request. It's now, unless there's a court order or there's a pending dispute, you must disperse the funds in 45 days.
So it seems that this is a pitfall. I know we're not going at discussing pitfalls now, but it seems like lawyers need to be very careful, because this applies to anyone who has an interest, and that's the time requirement, correct?
Right. Although the time requirement is when there are no longer any disputes, right? But as long as there's a dispute, the 45-day limit doesn't apply. Although I personally, reading between the lines, I wonder if, to the degree that some of the funds are undisputed and some are disputed, whether there's an expectation that you will disperse the funds that are undisputed, but continue to hold the funds that are disputed until the dispute is resolved. Obviously, this is a new rule, so we don't have any disciplinary records or cases interpreting it, but I would be careful about that and look carefully at the portion of any funds you're holding that aren't disputed and make sure that you timely distribute them, whether or not the people entitled to them have actually asked you for the money. Next slide, Hayward, please. So in addition to the changes to the trust account rule, there also were some changes to Rule 1.4, which is the rule about communicating with clients. And while that rule didn't change that much, what they built into the changes to Section 1.15 or Rule 1.15 is that if you fail to give the notice that you've received funds, or you fail to distribute the funds, that can be a presumptive violation of the communication rule that basically says, what they've added now is in the comment is that these requirements about trust account communication actually in some cases would be, if you don't do it, it's presumed that you have violated Section 1.4. So they've sort of built-in belt and suspenders approach is not only would you're not following this be a violation of 1.15, but if you didn't communicate, it's also a violation of 1.14. Next slide, and I think we're moving on to Mary talking about some
Me,
recent ethics
yeah.
opinions.
Thanks, David. We're on slide 11 of 51, and we got all these little time limits. So this is going to be a speed one minute or less. As most of you know who read the papers or watch TV news, the state bar is kind of under the is a bit under the microscope these days too, as to how they're handling complaints and what they're doing. I make it a practice of reading appellate opinions, both published and unpublished, in my areas of practice as a mediator. But I really haven't taken a quick look at the state. I'm hearing something else. The state bar rules. So this is on handout page 12 of your handout packet, and you don't need to pull to it now, but that gives you the link to these opinions, and I think we actually have it here on the slide. So I pulled some opinions that I thought were really interesting, and I'm not going to read the analysis or the facts because we just don't have time, but I'll just give you a real quick summary, which you can see on the slide actually. Starting with the last one at 2015-194, that's a real good one because almost all lawyers get involved in trying to settle their cases. I hope if you're either a litigator anyway, maybe not a transactional lawyer. So it has a really good discussion on the difference between puffing and posturing, which is okay, versus lying and making misstatements of fact, which is not okay. Although, I kind of thought, wow, we really need to tell people what's a lie and what's not a lie. But anyway, puffing and posturing is a statement made that's extremely unlikely to induce reliance. And I think that that's probably in one of the jury instructions as well. So there's a real good discussion. It's a 7-page opinion on the facts and the issue involved. Then the next one, I'm going with the oldest to the newest ones, the 2019 198. Attorneys have an ethical obligation to withdraw from a case where they know it lacks merit. So you're litigating a claim for a client and you get some information, and this case gives you more fact-specific stuff, where this claim, this is a malicious prosecution. So what happens if you have the opportunity to settle before you might have to withdraw? So the state bar gives some guidance there. And I think that's a scenario that comes up at least every once in a while with most lawyers who have busy practice. The 2020-204 on litigation funding. So that's a 10-page opinion, talks about ethical obligations the attorney has where a case is funded by a third party. And, that can come up, I think, in family law, in probate, also in personal injury cases where there's a contingency fee arrangement, or I did a lot of insurance defense work. So the client wasn't funding the litigation, the insurance company was. I haven't practiced law for over 25 years, I guess, but we had a standard letter we'd send to our clients, even though the insurance company is paying the fees, and we make, because we have to copy the insurance company, so we weren't going to insult them or anything, but we made it clear, you are the client, not the insurance company. And so your interests are the ones we're going to guard against. So that's a really good opinion to look at if that issue comes up in your practice. Duties to a prospective client. So that's the 2021-205. That's a long opinion too, 16 pages long. And the underlying facts had to do with a trade secret. So, people are prospective clients usually before they become your clients. So this gives pretty good analysis of what kind of duties you owe before you take the client on. The 2021-205. I think I just did that one. 2021, I'm looking at my little bit of notes here. Let me just do that one more. 2021-207, because a lot of my practice as a mediator, not as a lawyer, but a mediator because of my time on the bench supervising probate. this one on client with diminished capacity, what's the attorney's obligation? That's a pretty lengthy opinion as well. I think was about 17 pages long. That comes up often in probate cases. You have a client with diminished capacity and, what's your obligation there? And also personal injury cases, maybe where you have a client who's been injured, maybe a brain injury. Sometimes there's a guardian ad litem that's appointed, but there's some good analysis there. And then one other opinion that I pulled up for you is on colleague impairment. If you find that one, I think the senior partner was clearly impaired. There was Alzheimer's, and the junior partner, wow, what do I do? So that's just kind of it in a nutshell, because we have so much material to cover, but I think our goal is to at least point you in the right direction. So that's all for that one. Then we move to slide 12, and I'll introduce this one on civility guidelines, and David will give us a little chat before we get back to the
just so we're going to move into this part about civility guidelines. And hopefully all of you are aware that these exist, but if you aren't, well, we're going to remedy that. A couple of things I want to mention. First thing is kind of old news, which is back in 2018, the Supreme Court in California actually adopted the ABA model rules, which replaced and renumbered the earlier California rules of professional conduct. But as model rules, they are not exactly what California adopted, is not exactly what the ABA model rules say. So I would commend you, if you are looking into the ABA model rules, make sure that you look at the California version first. When you look online and see the new rules, you can see what the legislature and the state bar redlined out of the original text, and that's kind of interesting. But just in case you hadn't noticed, or nobody had cited a rule of professional conduct to you in the last 3 or 4 years, the numbering is now all different. The other thing that you may or may not be aware of is that the state bar itself has its own guidelines for civility and professionalism. They were initially enacted in 2007, but amended in 2014. Basically, the reason this happened, besides the chronic lack of civility that my colleagues have been talking about, is that the old rule under Business and Professions Code 6068F was that attorneys were admonished to abstain from all offensive personality. The U.S. Supreme Court, the Ninth Circuit actually took that up and decided that that was an unconstitutionally vague standard, although apparently there wasn't any dispute that the lawyer involved did not, in fact, abstain from an offensive personality. So here it wasn't the fact that he wasn't following the rule, but it was just an unconstitutionally vague standard. So the bar has adopted these standards. We're going to summarize some of them when we talk about them a little bit later, but it's important for you to know that they're there. There is a summary of those in your handout at page 13 to 14. And I neglected to mention, actually, when we were talking about the new rule of court 9.8.5, that is actually pages 1 to 11 of your handout, if you want to go back and read that. So, Mary, I'm going to turn it back over to you.
Good seeing me.
Yeah.
I'll move to slide 13, Hayward. Civility language in attorney oaths have been added in most, if not all, jurisdictions. So your handout in this one is at looks like pages 15 to 25, and I think credit goes to Aboda for providing this. So when I took my oath of office, I mean, it's so long ago, I can't remember, but I think the only addition to the California one, which I'm not going to read because you can read, is the part about striving to conduct myself at all times with dignity, courtesy, and integrity. So that kind of language has been added to a lot of states. I thought it would be helpful and interesting when you get some time to look over what some of the other states have added. Some of them are really quite lengthy. One of my favorites is Louisiana. The last part of the oath, I will never reject from any consideration personal to myself the cause of defenseless or oppressed or delay any person's cause for lucre or malice. Lucre. So other states use that term too. And then I kind of flipped through it last night, and one state, instead of lucre, they call it profit. And then Louisiana adds "so help me God," and a lot of other states have that. But it's kind of interesting to see the variation among the different states and the civility oath. So that's all on that one. We can move to the next slide. That would be 14. I hope I have some fellow ABOTA members out there. American Board of Trial Advocates. You cannot get into ABOTA. It used to be you had to have 20 jury trials under your belt. Now they've lowered the limit to 10, recognizing it's just a lot harder to get jury trials in the last couple of decades. And having a certain number of trials, like you meet the minimum standard, doesn't mean you get in. It's invitation only. And so I'm real proud to be a member, because I had an attorney, it was at one of my last jury trials. He comes in and I got 100 jury trials under my belt, Your Honor. This is how I do voir dire. And I thought, well, you don't know French, it's voir dire. And I asked, because he had a reputation for being extremely aggressive and uncivil. So I said, oh, well, you must be an ABOTA then. Nah, not ABOTA. That's just for defense attorneys. Well, ABOTA is for both plaintiff and defense attorneys, dedicated specifically to preserve the jury trial system. But it's not just that. It's about not just about good lawyering, but giving back to the community. So ABOTA has a lot of really good materials and programs on civility. Their Civility Matters program. And I know later today, some of the speakers are also members of ABOTA. So they're dedicated to civility, integrity, and professionalism, because this is not a job, it's a profession. Let's see what else in the ABOTA that I wanted to cover. Mutual obligations. Yeah, I went over all this again last night, and I like that it's not, because ABOTA members aren't just attorneys, but they're also judges, but probably mostly attorneys out there. It's kind of hard to tell judges anything, but other judges can. I really liked that in the ABOTA principles, they've got some rules for judges, like in terms of scheduling. Attorney tells you, Your Honor, I've got 2 jury trials set that day that you want to set. Could maybe you pick another date? Nope, and you better be here or you're gonna be in contempt of court. So that's not cool. The standards talk about discouraging conduct that demeans, hampers, or obstructs our system of justice, and that it applies, like I said, both to attorneys and judges. Attorneys should be resolving their disputes in a just, courteous, and efficient manner. So the handouts here give you a lot of helpful information. And again, one would hope that this stuff is already wired into your DNA as an attorney. So certainly don't mean to insult anybody, but just give you what some of the resources are out there. Next slide. I think this gets us to some of the local, not local rules. That's another red flag, but various bar associations. OCBA is mine. I've been a member for, I guess, 45 years. Orange County Bar Association civility guidelines, and that the 3 bullet points I gave you are the intro to each paragraph of those guidelines, and that's attached as your pages 39 and 40 of the handout packet. But I like the preamble, so I'll read that. The practice of law is a noble, time-honored profession, requiring and inspiring trust and confidence. Lawyers rightly take pride in seeking mutual cooperation and maintaining personal dignity. And we've attached the LA County Bar Association guidelines that are handout pages 41 and 42. And I didn't have any quotes for the PowerPoint on it, but I pulled out one last night for myself. We can disagree without being disagreeable. That's a really good line. And I think most of the major bar associations have civility guidelines as well. So, it's not mandatory, they're guidelines, but they're worth looking at. Next slide. So this is the ACTL, American Academy of Trial Lawyers. Wait, what's the C part? I've already forgotten. Anyway, the handout there is just a 2-pager. It's 43 and 44. I didn't want to do anything with anybody to copyright, so it's a big packet. So the Code of Pretrial Conduct talks about scheduling written submissions to the court, civility in your communications with the adversary, and in discovery and in motions. And I'm sorry if it sounds like I'm blowing by all this stuff, but my colleague, Judge Bruguera, is going to be digging into this in a little more detail, and we'll have some roundtable on it. It's already 9:15. And these standards also have trial standards, and those cover how you handle your client relations, what's your courtroom demeanor, and so forth. So these are all, it's really good stuff. And if nothing else, if you're a senior attorney or partner in the firm and you're bringing on new associates, point them in the right direction to this. I just have one more comment I want to make, and then I'll turn it over to David, because that's it for my slides. I remember I took a civil procedure from Jim Hogan at UC Davis, like 1974, and I can't remember much of that class, except I remember he talked about a case where somebody lost their license to practice because of bad conduct. And he got really teary, and he said, you work really hard to get where you are, to get through college and then law school, and to get that law degree and to practice a profession. No client, no partner, no fee is worth risking that. So with that, we'll turn it back over to David. I think you have the next slide.
Well, as you might have guessed, because you and I have been the only ones talking so far, it's actually now time for Suzanne, to tell us about the LACPA civility guidelines.
Well, good morning. It's wonderful to be here, and it makes me to know that my friends are out there. So LA actually has adopted the guidelines for civility in litigation as part of the local court rules, and so that has given lawyers I think a better weapon than just not just, but bar guidelines, because this, I know, these guidelines were cited to me in my law and motion practice when I was on the bench. So, practically speaking, if you come across attorneys that are not civil in their practice with you, and I know that seems to be happening more and more, I hear, that these guidelines can be cited in your, if it gets to a point where you're actually in motion practice. Hopefully you're not going to get there and you'll resolve it, but at least you can cite it to the other side, at least in Los Angeles. And it starts out with continuances and extensions of time. And it actually says that, you're to give the other side the first extension if they're asking for it. And when the other side gives you an extension, they are not to try to extract your rights, your substantive rights, such as a demur. So if somebody gives you an extension, they can't say to you, well, that means that, you can have it, but you can't bring your demur. And as far as service of papers, the guideline actually talks about service on Friday afternoon and before a long holiday weekend. And you would think that doesn't happen, but it's certainly, you know, it has happened to you, that you have been served that way. And particularly now with email, service is, you've got to be really careful with service. Also, it covers written submissions to the court. It says that it's something that we all know, that you should not be disparaging the ethics, morals, or integrity or personal behavior of your adversary. And so I know that that is part of your life these days. And it also covers letters. I know that in my law and motion practice, when ruling on motions, attorneys attached the horrible emails and letters that they got from the other side. And sometimes they would, fight back. Now, while I was getting ready for this, I spoke to some of my friends that are still on the bench. I've been gone for 7 years, but I still remember my law and motion practice, and asked them what is it that they don't like, and just to tell me about their opinion about civility. And one of the things that the judges, and I think they're research attorneys that work up the motions for them, don't like is when lawyers are so mean to each other and lack civility in their paperwork and correspondence with each other. And the best thing that you can do when that happens to you is to not respond, and respond in a civil way. I mean, a couple of judges actually said that they verbalized that when you are being attacked, you should refrain from attacking, and that will make you look good, and it will hopefully have the judge rule for you and understand that what is going on with lack of civility in your case and how much time and expense it has taken. So another very, and also it talks about motion practice and interrogatories and document demands. And of course, the meet and confer is one of the biggest issues. And I think it's because, we know that if you meet and confer properly, you can avoid so much lack of civility later on. And I will go on to discuss that in, let's go on to the Carton case. So the Carton case deals with, thank you, a lawyer who was having his house renovated, which I'm constantly wanting to do and haven't done, and found out that his contractor was not licensed. Now, there wasn't anything wrong with it. There was a dispute as to the amount of money that the contractor was charging. And so the work stopped. And at that point, the dispute was over $23,000. And so they were not, Mr. Carton and his contractor, RE Design, were not able to resolve their $23,000 dispute, and litigation happened. And this is an important case because the court actually reduced the attorney's fees request from $300,000 to $90,000, and not because perhaps the lawyer took too long to do something or billed too much to do something, but for actual over litigation over this case. And you could see that this case was very careful in analyzing all the different methods of that judges and arbitrators use to give attorneys their fees. And through each analysis, whether it was the lodestar or the percentage of recovery approach, which you don't see too often, they decided that the attorney's fees, that there was so much over litigation that the fees needed to be reduced. And so the court said that, a lot of the over litigation, if not all of it, was because of fact that the plaintiff was his own lawyer, but this really applies to representing others too. So the court said that we should go to the next slide, actually. Oh, you did. Okay, we can go on to 18. That the size of the judgment is pertinent to rational evaluation of a requested fee, and that rational decision-making weighs benefits and costs, and that weighing cost and benefits, the trial court concluded that a fee much larger than the judgment was not reasonable. So the fifth analysis was that the over litigation also included so much attack on the other side, against the other side. And this is where there is a emphasis that civility is an aspect of skill, and that excellent lawyers deserve higher fees, and excellent lawyers are civil. Sound logic and bitter experience support this, and that that civility is an ethical component of professionalism, and civility is desirable in litigation, not only because it is ethically required for its own sake, but also because it's socially advantageous. It lowers the cost of dispute resolution, and it for everyone, and thus it allows more access to the courts. It tends to be efficient, and it allows dispute on core disagreements. So what does the Carton party do once after getting the ruling from the court reducing, and in appealing that reduction to $90,000 instead of $300,000, he responds to criticism with more personal attacks in the appellate court briefing. And well, this did not go well for him. And I think it's an extremely significant case because of the analysis. You know, lawyers want to get paid for their work. And here there was a great amount of discussion regarding over litigation. We can also go over to the Davenport case when we're dealing with over litigation. Davenport was a case, was a family law case. And David will tell us later that family law has its own rules, and that the object, the goal of family law cases and family law litigation is settlement. And this case really discussed that goal in a family law situation. And even though the community in this case was rather large, I think it was $30 million, because one of the parties owned a car dealership, I believe. Even though the community was large, the court went on to say that it really did not warrant the amount of litigation and hostility and incivility that was being used in this case. But though it was a family law case, the court said family law cases are not supposed to be conducted in an adversarial proceeding. But even though it was a family law case, the court really stressed the fact that this applies to all cases. The quote is that they want to remind counsel that all counsel, regardless of practice, regardless of age, that zealous advocacy does not equate with attack dog or scorched earth practice, nor does it mean lack of civility. And so zeal and vigor in the representation of clients are commendable, but so are civility, courtesy, and cooperation. They're not mutually exclusive. And one of the issues in the Davenport case was the lack of meet and confer, because one of the lawyers said that if the other lawyer was going to be present at the meet and confer conference, he was not going to attend, and because there were several lawyers. Clearly, the judges, the entire state, expect more with the meet and confer process. And several of the judges I spoke to about this really stressed the fact that sending out an email with your position on it is not meeting and conferring, and that meeting and conferring in the olden times used to be knees under the table, is I remember the older judges, I'd say 30 years ago, would say. And but now, you know, we can't, it's not practical to meet each other. But you might be surprised to hear that the judges expect at least a telephone call with each other as far as meeting and conferring is concerned, and not just sending out emails. And so if there is proper meeting and conferring, then so much of wasted time for the client, time and money for the client and for the court can be saved.
Suzanne,
Yes.
could I just underscore a point? And
Yes.
I know we do have some family law lawyers
Go ahead.
in the audience, and you know, we're talking about Family Code 271, which does only apply to family law cases. And what it specifically says, actually, can we go back to slide 21? Hayward, thanks. That anyone who frustrates the policy of the court in favor of settlement can be subject to sanctions. I know, generally in my experience, 271 sanctions are very difficult to get. So here's a good example of a case where they, albeit this is now, whatever, 11, 12 years old now, that did support sanctions for incivility. The other key point that I want you to notice is that in this case, the sanctions were actually assessed against the client, even though it was the lawyer who was uncivil. Now, we'll be talking about another case later where it went the other way, but just note that when we're talking about incivility, it's not just you, the lawyer, who might be subject to sanction. Your client might be subject to sanction for your behavior. And imagine how a family law client will feel about that. If you have anything more to add, Suzanne, or should I move on to the
You can move on.
guidelines?
Go ahead.
Okay. Well,
One thing I just want to say, because we've had a couple people say, well, it's not on the slide, so some stuff we're talking about might not be connected to a slide. Oh,
right.
well, so sorry about
In fact,
that.
near
We'll give you
the
the
end,
citation.
Yeah, near the end, there won't be any slides. So just so you're warned. Okay, so we did mention before the state bar guidelines, the guidelines of civility and professionalism. Now, all this stuff is available on the state bar website. And in fact, when you go to what they have labeled the civility toolbox, in addition to getting seeing what all the standards are there, there's a list of all the local bar rules, some of which we had talked about, which really were the basis for the state bar rules. They didn't really reinvent the wheel. They looked at what all the civility guidelines in all the various counties were, and then applied, came up with this that's statewide. So if your county doesn't have their own guidelines, then certainly the state bars apply. But if you're in a county that has its own set of civility guidelines, go to the website. You could either go to your county court's website or go to the state bar website and click on the link to your county civility guidelines so you can see exactly what they're talking about. So in terms of the general idea, I want to just cover a couple of high points, because obviously you can not only read the rules yourselves, but there are extensive commentary to them that help explain what's expected. So as you can see from the slide here, right, attorneys have a responsibility to the justice system to mandate dignity, decorum, and courtesy. And there is then section 3 says, suggests that you explain to your client that you would not be an attack dog. And so adding on to what Suzanne was telling us about the Davenport case, at the end of the opinion, the court says, zealous advocacy does not equate with attack dog or scorched earth, nor does it mean lack of civility. Zeal and vigor in the representation of clients are commendable. So are civility, courtesy, and cooperation. They are not mutually exclusive. So again, some years before the bar adopted this was already part of our case law. Next slide, please. Okay, so section 4 really talks about civility and written work. So it's asking you to reflect and consider, when you're writing things, that you do so with decorum, that it is not disparaging, no matter how tempting it might be to disparage opposing counsel. That is not civil, and definitely avoid hostile, demeaning, and humiliating words. Again, here, when we had looked back at this Davenport case, right, you can harm your client's case with your behavior, and that can happen consciously or unconsciously. And so if you have been accustomed to maybe not mincing words when you're in court, you may want to reconsider the impact on your client here in written work, but also when you're making court appearances. Next slide, please. Section 6, it's about scheduling. And again, these are a lot of the same rules that Suzanne was talking about that are part of the LA. So first of all, tell your client that you're going to act professionally and civilly, and that results in lower legal fees. That's usually a message that clients are open to, even though they may have come into your office the first time and asked if you are aggressive. You are expected to agree to reasonable requests for continuances that are not adverse to your client's interests. So that means not holding a continuance hostage for some other quid pro quo. You are expected to handle scheduling conflicts with your counterpart and not bother the court with those. And again, if you need a continuance because something has happened, that's one thing. But if you're doing it strategically, that's not inconsistent with the guidelines the state bar is promulgating. Next slide, please. And then discovery. Again, as Suzanne was talking about in the Davenport case, meet and confer is important. I don't know about the other family lawyers here, but I was accustomed in my litigation days to appear for court and be immediately directed by the bench to go outside and meet and confer before having any sort of hearing. So at least in the courts I practiced in, that was definitely a mandate. Again, not You're not supposed to use discovery to harass. You are not supposed to strategically set a depot before a depot for the other side is set. This is a good one that I'm sure my colleagues can appreciate. Do not do anything at a depot you would not have done in front of a judge. I think that's something that's often forgotten. Of course, you get a privileged document, you notify the other side and return it. You don't delay production for tactical reasons, and you don't produce documents in a manner that obfuscates, such as sending 75 boxes of irrelevant material when there's one file that's actually relevant to the request. Next slide. Okay, now there is a special rule in these, Rule 19 or Section 19, that applies to family lawyers, and this, of course, is consistent with Family Code 271, which is basically saying if you are practicing in family law, you are supposed to discourage and not abet vindictive conduct for non-family law lawyers. This is a no-fault state, and bench officers get really tired about hearing what bad things the other person did to you because, you know, that's just not relevant to their decision. You are expected to treat all participants with courtesy and respect to minimize the emotional intensity of a family dispute. I don't know if the criminal lawyers say this too, but we family lawyers tend to talk about criminal lawyers represent bad people on their best behavior, and family lawyers represent good people on their worst behavior. And this is usually an emotional time for those clients, and so you as a lawyer are expected not to exacerbate that. And the other thing that's really quite key is that in a lot of these cases, minor kids are involved, and the psychological research tells us that it's conflict between the parents that is most predictive of a bad outcome for children when they grow up. So, and that happens to be true whether the parents stay together or break up. So the duty here that's being presented of reducing conflict in a family law case is something that really benefits the children, not just keeping things civil for civility's sake and the social goods that we've already talked about.
Okay, David, let me say something about deposition since oh,
sure.
Okay, so as far when we're talking about how you can be hurting your client, the Crawford versus Chase Bank case, which I believe is in your materials or in a slide. It was something that doesn't normally happen, but there was a motion for terminating sanctions and it was granted. And so the litigation was very uncivil because one of the lawyers showed up with pepper spray and was threatening the other side. But the language in the case, the language in the case talked about all kinds of incivility and granted terminating sanctions. And the one thing I wanted to let you know, and I think this is statewide, I did not give you the name, but it is the California Judges Bench Book. So if you Google California Judges Bench Book, you will see that the California Judges Association, the education section, has a lot of pamphlets on or guidebooks to judges. And it's available to you if you Google it. And this is what judges use when they have a question, when they're researching. That's what one of the things that research attorneys use. And so you can quote back language to the judges that they're reading. And as far as depositions are concerned, I know that their depositions become a problem for lawyers. Sometimes there's the emotion is high, and in fact, the cases talk about the emotion being high in depositions. And I believe it's the Kimmel case that says that you need to, it's okay to wait until later to have a meet and confer about what is going on in the deposition. Once again, you should not suspend the deposition. You should go forward. But if there is an issue and it's an emotional issue, it's okay to discuss this at a later meet and confer and try. The other thing
just for the audience though, so I'm looking at, those cases, the Kimmel case is on slide 35. We don't
Thank
necessarily.
you. 30,
Yeah.
that's right. Thank
The
you.
class
35.
notes, yeah. And then that other case, Crawford is, I don't know if that's on a slide, that's 242 CalApp 4th, 1265.
Thank you, Mary.
242 CalApp 4th, 1265. Yeah, we have a lot of material that's not on the slides because you'd have a 200
It's
slide deck. Yeah.
So
Use the internet.
this judge's bench book actually has a chart that says the types of objections that are valid in a deposition. There will be disagreement, I believe, but at least you can see what judges may be looking at when they're looking when they're ruling on your motions as far as depositions are concerned. And so did I interrupt?
So yeah, just to finish up the rules, and I neglected to mention again that in your handout there is actually the summary version of the bar civility things, and I think that's at pages 13, 14 in your handout. Another source for family law practitioners, I believe there's a link, not a link, but a site there for you to the bounds of advocacy that are promulgated by the American Academy of Matrimonial Lawyers. And again, these are standards that apply specifically to members, but it's also a good place to look for a more expansive view in terms of what is expected of highly effective family lawyers. Slide 26, please. And there is a special rule for criminal law practitioners as well. It's the only other special rule. And it really has just two pieces, which is that, a prosecutor should not question the propriety of defending a person accused of a crime. Although it's now occurring to me, oh, I see, that's the prosecutor doesn't question defense counsel. I thought, why is the prosecutor defending a person accused of a crime? And then appellate counsel and trial counsel should communicate openly, civilly, and without rancor, endeavoring to keep the proceedings on a professional level. So, Suzanne, I'm going to kick it back to you. And there's actually been a question already about how do you get these rules to apply in your cases, right? How do you hold opposing counsel, or how do these things get implemented?
Yes, isn't that the problem? And
yes. Slide 27, Hayward, please.
Yeah, that's what I was thinking about when I was talking to my former colleagues that are still on the bench. And you need to do your best. And if it comes down to motion practice, or if it comes down to meeting and conferring with the other side, I think that it's a big deal if you can quote something from the judge's bench book and say, look, you're wrong. This is the law that the judge may be looking at. I mean, there are instances where the courts, of course, it's gone through litigation and they've been applied.
So, Suzanne and Mary, let me pose a question to you. And can we go to slide 28? So there's a suggestion in there that one of the things courts could do is issue orders or standing orders, as listed here on the slide, that indicates the court is expecting counsel to follow those guidelines, and that there's an expectation that all disputes regarding scheduling or extensions are going to be handled without court involvement. What comments would either of you make about issuing those kind of orders in cases that you're handling?
Yeah, I'll start. I think have to be careful about, and this is more for the judges, I guess, about that, guidelines rather than local rules. When I was practicing, I practiced all over the state, as maybe a lot of you do, as a civil trial attorney. And, I go to Sacramento and then they have their local rules, and those are all supposed to be gone now. But I was at an event sitting next to a good friend of mine a couple weeks ago, as a family law lawyer, and she was telling me about family law panels that have their own, they call them guidelines, but they're really local rules. And there's the California Rules of Court, which we're supposed to be familiar with, and then in your county has its own local rules. But then judges, So when I was first appointed to the bench, and everybody gives you all these ideas of what to do, and I started gathering people's guidelines, and I thought, I'm not going to tell attorneys, where to stand and this and that. So it's really kind of specific to your judge. I mean, I'm kind of a fan of keeping, if you have guidelines, maybe keep them on one page. But I swore when I swore my oath of office as a judge, I would never forget what it was like to practice law. And I didn't. So I just tried to keep my guidelines really short and not something new that fell afoul of the California Rules of Court. Suzanne,
Well,
any thoughts?
Let me add that you really, as a judge, your local rules are disfavored. Several California Chief Justices ago sent, I think it was like 20 years ago when
Time flies.
Yeah, when we got the order that you should not have local rules because the lawyers want to be able to practice everywhere, and you shouldn't have your own local rules.
Well, and in family law, Suzanne, we had the Elkins case, which actually changed some of the draconian local rules in Contra Costa County for pro per litigants. On that, the Supreme Court said that, and that was on that same idea. Sorry to interrupt you, but
that's okay. So I was very on the bench. I was very hesitant to have my own rules. I didn't, but I did try to get people to be civil to each other, because I was, if I could see that someone was not civil, I didn't like it, and they could see it in the ruling. So there is, as far as implementation, when we were preparing for this, one of the topics was that judges refer lawyers to the bar when they see this type of behavior. And again, I sympathize with the lawyers because judges rarely refer attorneys to the state bar. In this instance, this is this one instance that where there is a sample minute order. You have it in your materials. I believe, where is the Doyle?
I think we're going to get to that a little later, Suzanne.
Okay,
so
but let me just say that in this case, the attorney said, "See you Tuesday." They had a big battle in the court. The attorney said, "See you Tuesday."
Next Tuesday.
Next Tuesday.
Next Tuesday.
Okay, I better remember. See you.
Yeah, see you next Tuesday.
Yes,
one of my fellow Abota members sent that to me out of San Diego court. Go ahead,
my
Suzanne.
goodness. And the judge naively said, "Oh, that's wonderful. How nice of you." They came back on Tuesday and found out, and one of the other lawyers talked about how that was really, I don't want to use the word, it was an amazing insult, because see you next Tuesday, the first.
Think about the letters.
Think about the letters. And the judge referred that case to the state bar, that attorney, because, the judges do have an obligation to run the courtroom fairly and and in a way where it's going to get respect from everyone, and respect is shown to everybody.
And if you didn't
Suzanne,
infer it,
wait,
the
Go ahead.
lawyer who made the comment was male and it was directed at a female opposing counsel. Probably doesn't need to be said, but that was the
it
context.
doesn't. Yeah.
Eddie Sturgeon wrote that wonderful minute order, and that went up to the state bar too. I just want to segue back for a minute because I'm trying to look through a lot of the questions to see we get things answered.
Good.
A lot
Okay.
of people well, Suzanne, a lot of you mentioned a book that judges use. So a lot of people are wondering, what's the title of that book?
It's the California. It's not a book. If you
It's the guides.
I didn't want to just put it in the materials, but if you Google California Judges Bench Book, and you will see that there are bench guides in many different subjects, and sanctions is one of them. It's courtroom control, and the discovery is such a big topic that it's not just a pamphlet, it's actually a book. And it has the chart for the objections for depositions. So I think that's something lawyers should know about, that's the education that judges are being given. You may not agree with everything that's in there, but you at least have it. And before we could Google things, that wasn't available to lawyers. And now it's on the internet. I think it's wonderful. Sorry.
So let's move to slide 29 just quickly. I know somebody asked a question about, how do you get this to apply to attorneys? And again, technically, these are voluntary, but a couple of suggestions that are in the guidelines are ask your opposing counsel to sign a pledge and say you're going to sign that pledge and see if you can get their cooperation, and hopefully the judge would enforce it. And again, as was mentioned before, tell your client that this is how you practice. And if they expect you to be more aggressive and impolite, that perhaps they've hired the wrong attorney. So let's move on. Suzanne, you're going to now talk about civility and appellate practice.
Okay, so when you the court wants to make sure that you follow the rules as far as in an appeals. And so the court, there are several cases where sanctions are imposed for not following those the procedure, including re-arguing the case on appeal. Of course, the cases deal with civility, and so the lawyers were complaining about and using terrible language as far in regards to the trial judge. And so, as you may imagine, the appellate judges are not will not look at that very, very well. In fact, the case, let's see. Yeah, that I can leave it at that. I wanted to tell you that there is a case called Kimmel versus Goland, which is the slide 35. This opinion was written by Justice Arabian, and it talks about how having illegally tape recorded the other side does not fall under the litigation privilege. So, as far as technology is concerned, that's something that you should know. And this is a very recent case that generally wraps up what we've been talking about, which is In re Mahoney, where the court said that the court found a lawyer in contempt for not, for on appeal, for not actually arguing the law on appeal, but just attacking the judge, the trial judge, and the appellate justices. And so this is where the court says, we published this decision as a cautionary tale. The timber of our time has been unfortunately aggressive and disrespectful. Language addressed to opposing counsel and courts has lurched off the path of discourse and into the ditch of abuse. This isn't who we are. And so, I was going to wrap up with that. And do you have any war stories? This was going to be our war stories time.
Oh, I'm answering a question. So trying to get one. War stories about bad conduct.
So did you, Suzanne, did you want to discuss some of the appellate rule 8.204 or the Parati case about frivolous appeals?
That yes, the Parati case deals with the rules on appeal. In fact, the lawyer who was not following the standards on appeal, which is not re-arguing the case, was sanctioned. And so not only was the lawyer sanctioned as far as and having to pay attorney's fees, but that sanction went to the appellate court. And so it's important to follow those rules. And that is the Pirelli case.
And I think you were.
Let me, I did want to tell you about the mediation confidentiality. You may, as a practical matter, you may want to ask your mediator to discuss the importance of not talking about the case to your client. Sometimes we also have forms that we can offer the attorney to give his or her client. And as a practical matter, again, one of the judges was telling me that when lawyers, and this is in terms of MSCs, when the lawyers hint around settlement discussions, it is really something that judges, it is distasteful and is something that, should not be done. So that's a major pitfall. And you will see that another pitfall, and I think this is that we need to think about, when you read the decisions regarding suspension of attorneys, almost all of them deal with communicating with clients. And so with these regarding trust accounts, I think communicating with clients are going to be even more important in the coming time.
I don't know if everybody's looking at, the panelists are looking at questions and answers and trying to answer as we go. I just want to mention one that I answered, and somebody asked about objections for depositions, what are good ones and not so good ones. So I will upload have Hayward upload to our webpage for this class the handout that I use, because I didn't do it for this course, but when I'm a referee in depositions, I have a handout I send to all the attorneys, and just like a general reminder, as you probably know, there are very few proper objections for depots. So we'll get that uploaded to the website within about a week or less. I just wanted to make that so. Okay. Who's next?
We're sort of jumping around here.
We're getting there, 5 after 10.
Yeah. So can we?
So David, I think you can go into your materials.
Oh, okay. Well, I guess I want to just add one family law specific thing to. Let's see. This is going to be. Actually, sorry, we don't have a slide on this. So this does have to do with for family law practitioners. There was a case a few years ago having to do with confidentiality of custody evaluations. And we know we have a statute, Family Code 3111, that says those must remain confidential. And 3025.5 says there are certain people who are allowed to have access, parties, counsel, and court employees. And in 2019, a case called Anchor and Yeager came down. And the facts essentially was there was a couple who divorced, and there was a custody evaluation involved in that divorce. Wife remarried and then was divorcing the second husband, and the attorney for the wife in both cases took the first husband's deposition in the second divorce case and asked a bunch of questions about what the custody evaluation had said about mom. And the court looked at that and said, you know, A, that's a violation because even if you weren't actually disclosing or reading information, your questions were disclosing what was in the evaluation. And this is perhaps a more troubling practical part, the court said, oh, and court reporters and videographers are not court employees that are exempt. So besides there needing to be making sure that you have court permission to use the content in another case or even in the same case of a custody evaluation, anytime you're taking a deposition of an evaluator, if you don't have court permission that allows a court reporter and videographer to hear that information, you could also run afoul of these rules. So the other thing I guess we're going to try to cover very, very briefly, and this is really, let's tag this onto what Suzanne was talking about communication, right? And can we go to slide 36, please? Hayward, okay. So we talked a little bit about some changes, but there are not a ton of changes here. But the idea here is, you know, you're supposed to keep the client informed, but that's kind of a two-way street, right? Clients don't necessarily, in fact, all of us, don't take in information the same way. Some people take in information in writing better than they take it in hearing, and some clients take it in audibly better than reading. So part of the task of the attorney is to make sure that you are providing information to the client and the client is taking in the information, particularly in instances where they need to give informed consent to those decisions. The other thing that is sort of, we now know from neuroscience, is that when people are stressed or people are feeling threatened, and of course, a lot of our clients, certainly in family that's true, but also in other parts where people can be really activated or feel threatened by legal action, we humans are hardwired to give to make a defensive response. Let's see, next slide, please. And partly that has to do with the fact that we have three different parts of our brain. Next slide. We have a very primitive part of our brain, which is often called the reptilian brain, which is sort of the most basic part, and we share that with a lot of invertebrates. There's the mammalian brain, which mostly processes things like emotions, and the primate brain, especially the prefrontal cortex, is the part of our brain that thinks. When a client feels threatened or has a defensive response, the thinking part turns off. And what gets engaged is the reptilian brain, which basically says fight or flight, or feign is often sometimes included in that. So sometimes people will have this response and they're not thinking and they're not taking in information. So you need to be aware when you're talking to clients, if they are in that agitated state, they're probably not taking in information very well, and they're probably not in a position to make good decisions for themselves. And of course, this can also happen with opposing counsel, and even with yourself. When you are being treated uncivilly, you might then have a very defensive response. And I guess what I would suggest is be aware of that in yourself. And there were a lot of questions about how does one respond to incivility. Well, one of the first things you do is don't respond with incivility on your own, but that means you need to get over your own trigger to be able to then think of an appropriate response to make in the moment. So that's just a pointer there. Next slide, please. The other part about communicating with clients is you do really need to confirm understanding. So, you know, if you're going to get informed consent, the client has to actually understand what the choices are. It's also pretty true of clients, in my experience, that if they don't understand what you're telling them, they're not going to admit it. Clients don't say, I didn't understand a word you just said, would you say it differently? They'll just nod their head and say, okay. So in my view, you have an obligation to make sure that the client has heard it. Now, sometimes we do that by sending a letter and asking the client to sign it. And again, for people who are visual learners, that's going to be easy. For an auditory learner, that might not work. Similarly, just telling the client in a conference may not be enough if the client is a visual processor. So you need to take steps to make sure they understand. And that might require you to say, can you just say back to me, or can you tell me what you understand about the choices I've given you? And see if the client can come back and say, these are my choices. If they can't do that, then you know you've got a client who is not thinking, and then there's a question about whether any consent they give you is actually informed consent. So the takeaway here really is just telling the client your advice and the information you think they need to know may not be enough to actually get that information inside the client's head, and sending a letter in some cases might not actually be enough. Now, for purposes of your ethical responsibility, I believe it's the position in the state bar and the current rules that sending documents to your client satisfies your obligation to keep a client informed. I guess I want to suggest that while failure to communicate with your client may or may not result in a violation of CRPC 1.4, but at the very least, it's certainly going to impact your client's feelings and impressions about how the representation went. Did it go well or not? Were their objectives, whether or not their objectives were received, did they feel like they were heard and they were understood, certainly by you as their counsel, and ideally that they were heard by the bench officer. So keep in mind that at least in terms of collecting fees potentially and avoiding complaints or malpractice actions, thinking about how it looks to the client and paying some attention to that actually can help you avoid a lot of trouble. And I think...
Well, let me pose a question.
Sure.
As far as discussion with clients, I know we discussed the fact that your client may want you to be a zealous advocate in a way that you may not be comfortable being. How do you keep that client and still stay civil? I know in mediations, I never do joint sessions. When I first started, 6 years ago, I think the first couple, we had joint sessions, and they turned into just the fights that were, got nothing done. So I don't have joint sessions anymore, because it seems like no matter what you tell your client about zealous advocacy, they want you to be overzealous. And so what is the advice you give to the attorneys?
Can we get a slide?
I have one
39?
one little war story on that one. Yeah, I had, when I was a young associate in the firm, I had a doctor said, when you take her deposition, make it as miserable as possible. And I thought, oh man, I'm going to get fired, but and the insurance company won't be happy. But I said, doctor, I'm not practicing law that way. And long story short, carrier backed me. I got that doctor a dream settlement because of the attorneys trusting me and treating their client with dignity. So,
well, and we've covered some of those go ahead. Sorry, I was going to say at the front end, you should be telling your client, A, this is how I practice. You can explain to them about the civility guidelines. You can explain to them that it generally saves money to just not respond to the sort of useless back and forth. I can say in my practice, that was sort of how I always practiced, because I didn't want to get involved in petty disputes. And it was generally sufficient to say to opposing counsel, okay, I guess we disagree. We'll see what the judge says. Doesn't have to be threatening or adversarial, right? The assumption is if you're really tough, that somehow it's going to make the other side back down. Well, human biology says if you threaten the other side, the last thing they're going to do probably is back down. They're likely to give you a defensive response and make threats just right back to you. And that doesn't advance your client's interests. So A, if you are committed to practicing in a civil manner, that you need to explain that to clients up front, and that you are effective using that method regardless of what opposing counsel is doing, and that opposing counsel may very well be hurting their own case by not being civil. And again, you can be a zealous advocate. I want to hearken back to what I quoted from Davenport, which says specifically, well, there's Davenport, which just say, being an attack dog is not what we're talking about in zealous advocacy. Zealous advocacy is being clear on making sure that your client's points, legal and factual, are being made. The tone of voice and how you deliver that information to a judge or to a jury does matter, and it makes a difference to the audience. And I can say, at least in my experience as a litigator, I found judges appreciated it, and sometimes would, I believe, find counsel who was civil somewhat more credible in where there were disputes compared to somebody who was not. Now, again, I expect that would be completely unconscious on the bench officer's part. But again, civility, the way to demonstrate that you are a clear thinker and you are making arguments that you're demonstrating you believe are valid and worthy of the court's consideration. So that's how I suggest you respond: is don't fight fire with fire. Sort of use the Aikido method of litigation, which is let your opponent hang themselves.
Yes. Certainly civility is a bigger topic these days, in these years. I wanted to also tell you about the Jackson versus Park case. And it's a new case, and we will put up the site soon as we get off. But this case dealt with a civil case where just a civil personal injury matter, but the defendant had been arrested on a DUI. And so in the civil case, the judge said that that evidence was not going to come in. It was not relevant at the time, and I guess the support wasn't there. So it was not to be mentioned. But during examination, it was mentioned, and the judge gave a curative instruction to the jury that they were not to consider it at all, and told the lawyers not to discuss it as well. But the counsel for defense brought up in his closing argument against the judge's instructions that there was zero evidence of any arrest, and they were not to for DUI or any evidence of intoxication, and they were not to consider it. There was a motion for a new trial, and the motion for a new trial was granted. So there can be a great deal of consequence to civility issues today, I think, much more than they were before. And even in criminal matters, I think this is true. And so the Crawford case, nope, it's not Crawford. If you can wait one moment. The Chong case, I think that is all slide.
Somebody just asked when they're going to get a restroom break.
Oh, yeah.
We can't see you, so we're
Yeah.
about to
Well,
wrap
let me
up.
tell you, in the Chong case, it was a criminal case, and counsel was constantly arguing with the judge, and the judge did not have time to stop and admonish the lawyer outside the presence of the jury. And the person was convicted, and the conviction was affirmed on appeal, because the court said that there may be times when judges can't constantly send juries back into the jury room and admonish the lawyer, because the lawyer had been so disrespectful to the court and thus the system. And so even in criminal case, that is an important issue. Even in criminal cases, those issues are important. Anyway, are we getting restroom break now?
Since we've got 9 minutes before it's over,
Oh,
I would say the audience has
Yeah.
a choice of a restroom break or asking more questions.
Yeah, if you're going on for the next session, it starts at 10:45, so we will finish right at 10:30. We're about to wrap up, and it's a lot of stuff. So you'll have time, unless you want to do it now. We can't see what you're doing. Sorry.
Exactly. You will not be penalized by taking.
I've been trying to I've been quiet, but maybe not quiet enough for you guys, but trying to monitor a lot of the questions and get as many answered as possible. And there was a question about case citations, because we don't have all the cases on slides that you have. So the team we have our own internal outline, and we will put together a list of cases that were cited that weren't in your handouts or on the PowerPoints, and we'll get that uploaded. So that's two promises. That one,
I
objections
promise
to
to do
depots.
that.
And I don't know, so handouts at pages 26 and 27, and it may have been discussed, but it was one of the handouts is an article by Judge Lauren McMaster, unfortunately passed away, but he wonderful man, Sacramento County Superior Court. Tons of case citations in that article that we've given you. It's thoughts on improving civility and professionalism. So we won't, copy any sites that are in the materials we gave you, but I think there were some that maybe we threw out, and we'll be happy to give you that. That's what I just wanted to add. Lose my voice.
And I will upload that deposition chart that's in the judge's bench guide.
David, are we on slide 39? We got more to go?
No, I don't think we have any more slides, at least unless we're sort of launching into another section, which I don't think we need to do. I have been trying to answer questions, and I know you have too, Mary. I'm trying to see if there is some that we can discuss.
Yeah, maybe.
I'd like to appreciate the comment by Ms. Corman about the unintended pun that we made. Yes, exactly. So there is a question here where the person is asking about counsel asking for a lot of extensions of time that she granted, but then opposing counsel wouldn't reciprocate in any way. And so there was a question, how do we suggest you move litigation along when you're following the rules, but the other side is not? And apparently it was made clear later on that the opposing counsel's purpose was specifically to delay litigation and then substitute out right before trial.
Oh, my
So-
goodness.
So what could somebody like that do? Or somebody in that position do? Because there were a number of questions really about
I think.
what do I
that-
do when the other side is
Yeah,
not behaving?
that's really, I think that's what that was our focus, is trying to help people who have these issues. And you don't have to grant all extensions. The extension granting needs to be reasonable. And you are permitted to think about the litigation, the timely litigation of your case. And so the guidelines that are attached to the LA rules say the first extension should be given. But that's it. It just says the first extension. It doesn't mean every extension after that. I'm sure everybody wants that first extension. And sometimes you need a second extension, but you do not have to give unreasonable extensions. You can,
Yeah,
but when you do write that email, make sure that it's not attacking anyone. And I would, if I was doing lawn motion again, I would cite the guidelines, because the guidelines will help you. It says that you are to balance the interests of the case and in granting extensions after that first one. The more
Right, well,
you cite it back, the better.
well, and the other part is, it says you're expected to grant continuances when it doesn't prejudice your client. So that means if
Right.
somebody says for one continuance, that's fine. 2 continuances, okay. 3 continuances, if that is, in your view, prejudicing your client by delaying the case, that is an acceptable reason to say no.
Absolutely.
It's just, you just
and
don't say no. out of
most
the gate.
judges see through that kind of garbage too, hopefully. Most trial
Right.
judges, you
Right.
make a good record with either letters or texts or emails, or really stay away from texts. But most judges know where that uneven balance is. And so you just, was it the Michelle Obama said, when they go low, we go high. But again, you don't prejudice your client. I used to make a practice when I'd send out interrogatories. I just had a cover letter. I know they're kind of, these are a lot. And I almost routinely granted an extension first time. I said, if you need an additional 30 days, let me know, and you got it. Start out on a high note, and
just make sure that the email that you send out is after the conversation, after the discussion, on the phone. At least you try to talk to them on the phone, and keep on topic without personal attacks. Without saying you're trying to delay even though you know that that's the case, don't go there. It will be so helpful if you don't.
Yeah. I don't know if we covered this case specifically, but there's a case that basically says sometimes email isn't sufficient. Sometimes it's actually better to pick up the phone.
Oh,
that's
what the judges
remember in Judges College, Suzanne, Lynn Duria gave a talk about that, and she said, the E in email stands for evil. Don't put anything in an email you don't want on the front page of the LA Times. I never forgot that.
Yeah. And meet and confirm. You should meet an email. The first contact for meeting and conferring is not appropriate. You've got to try to talk on the phone. Several of 2 of the judges I spoke to said you should offer a Zoom meeting for a serious meet and confer. So I don't, that's a pretty good offer. If a judge sees that you've offered that, but I know what you're trying to do is avoid that lawn motion practice in the first place.
So we have a good question that I think we can wrap up in our last minute. Somebody has asked, what impact do you think California Civility Task Force report and the proposed changes to the rules of professional conduct will have on the profession? Kind of a broad question. I think we largely addressed that in the course of the program. I think the sad part is this has been an issue that has been on people's radar for 10, 15 years, and we're still seeing bad behavior. So one would hope that with greater dissemination and those of you in your practice reminding courts, A, that these rules exist, and B, that the bench officer is expected to enforce them, maybe bench officers will start helping you out and making opposing counsel behave.
Yeah, I think they will help. I absolutely, you're going to be telling you, and you'll be reminding the judges too. I think they'll have a strong impact.
All right, so I think with that, we'll wrap our morning 2-hour ethics program. Thank you, presenters, and thank you all for joining us and hanging in there with us. I know we promised a 5-minute break for a pee break, but unfortunately, we were not able to because there was just so much to cover.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.,